Okay, and so we are on the record in the matter of the state of Michigan versus Amanda Cheney. 28th District Court case number 23806.
Good morning, Your Honor. Tamika Tucker, PA 5402, on behalf of Amanda Cheney for her felony matter.
Okay. And Ms. Cheney, your name for the record, please.
Amanda Cheney.
All right. And so today is the date scheduled on the felony matter. Okay, well, we're going to handle the felony matter only, the 240396. And so, counsel, today's the date scheduled for the probable cause conference in this matter. And
Your Honor, I've had a chance to speak with Ms. Cheney, and she would like to waive her preliminary examination.
okay, so Ms. Cheney, you heard what your attorney placed on the record, correct?
Yes.
And you understand that you do have the right to have a preliminary examination where it must be shown that a crime was committed and probable cause exists to charge you with that crime. Do you understand that?
Yes.
And you also understand that by waiving your right to a preliminary examination, you will be bound over to circuit court for further proceeding on the charges in the complaint and warrant, correct?
Yes.
And you've received notice of the charges, correct?
Yes.
All right, the court will note examination having been waived, defendants bound over to circuit court for further proceedings. You are to appear in circuit court on May 24th.
What about bond on the other cases?
Excuse me, I'm not finished.
I'm sorry.
At 9:00 a.m. at the Third Circuit Court. Okay, ma'am, your misdemeanor matters are going to be handled as soon as we have the MIDC attorney from
They're keep separate.
28th District Court. So, Ms. Tucker, I'm going to order bond and conditions are continued on this matter.
Okay.
And then, Ms. Cheney, you're still going to be hanging out over there until Mr. Melito appears over here in court or on Zoom.
Okay.
Thank you. All right, and so this is the matter of 28th District Court, case number 240393 and 230806. And counsel? I'm sorry.
Thank you, Your Honor. I'm sorry, what was that, Your Honor?
I was just reading the name. I don't think I said the whole case, but State of Michigan versus Amanda Cheney. And so, counsel?
Oh, thank you, Your Honor. Attorney Matt Melito on behalf of the defendant who's appearing from Wayne County Jail has waived the right to be present. Ma'am, can you state your name for the record?
Amanda Cheney.
Okay, thank you. All right, and so, counsel, today's the date scheduled for the pre-trial in these matters. And counsel, after the pre-trials.
Yes, Your Honor. We're going to ask to adjourn the pretrial to kind of follow the felony, allow the felony attorney to be perhaps use the city cases as part of a global plea. So we just asked for adjournment of the pretrial. And also my client would like to ask for a bond reduction. It's currently set at $500. She doesn't have that money. And the felony judge has given her a PR bond with a tether. So we want to set this bond like that.
Okay, hold on. I'm getting a lot of noise over there. So I just need, I'm muting the Wayne County Jail for right now. And so, counsel, just, I'm not sure if you're aware, but the felony matter bound over. They waived and bound over to circuit court. So I don't know.
I'm aware, Your Honor.
Okay, all right. So we're going to schedule these matters. We'll adjourn these matters to June 4th. Okay, and so I'm aware that the in the felony matter, the magistrate, the 36th District Court magistrate said a $25,000 personal bond. And in these matters, that was a possession charge as well, was it not, counsel? The felony matter?
I believe so, Your Honor.
Yes, possession of. And these matters, possession of paraphernalia, concealed pistol, or concealed weapon, and false information to a police officer, as well as retail fraud 3rd degree. So this effect date was May 4th and May 3rd. Okay. And so Ms. Cheney, it appears as though was given a personal bond on either May 3rd or May 4th by the 36th District Court magistrate on her felony matter. And then as she was out on bond, then she now was arrested on the May 4th offense for possession of drug paraphernalia, carrying concealed weapon, and false information to a police officer. Is that about, accurate? No, Ms. Cheney's shaking her head no.
No, that's not accurate. I was arrested on the felony and the misdemeanors all in the same day. I went to court in Southgate on the felony, and they PR bonded me on the felony in Southgate. But then I got two $5,000 cash surety bonds with GPS tether on all of my misdemeanors.
Give me that, please.
So that's why I'm currently sitting in Wayne County Jail right now, because I have two $5,000 cash bonds, 10% with GPS tether.
Okay, and you seem annoyed by that, ma'am.
I mean, I have an 18-month-old daughter at home. I'm her mother. She needs me. I know I messed up, but I've been here since May 6th. I think if you could just give me a chance and PR bond me with my felony, that I will come to court and do as I need to do to be with my daughter.
Well, you didn't appear, you failed to appear in October at your arraignment on your retail fraud matter. And so what's happening with you have some other matters in the Allen Park. What's happening with those?
I do not know at the moment. I'm working on it. I'm sitting in jail. I'm working on it.
Well, I don't know what that means, that you're working on it. I
have not appeared in front of Allen Park. No, I have not.
Well, it says notice to appear.
I will appear if you even let me out on GPS tether.
Okay.
So you know where I'm at.
Well, hold on. What's going on with your matter out of Taylor, January 12th of 2024, felony dangerous drugs? What happened with that?
I don't know.
And retail fraud in November of 2023 out of Taylor, warrant requested. Allen Park, dangerous drugs, notice to appear. That was November of 2023. Oh, we have a case with her. You have a case with us, ma'am, do you not?
I think so. I'm not sure.
Okay, well, we're gonna just pull that up. We're gonna see what that is, because it appears as though you have a hard time returning to court or appearing at all. So we're going to recall this matter, counsel, so I can see if we have a matter here in our court. It appears as though we do. I'm going to see if we can find it with our GIS being down. So let me, so if you can give me just a couple minutes, okay? Let's go off the matter.
Okay. Go! Hand me my screen box.
Now go.
Okay, and so we're recalling the matter of Amanda Cheney, the city of Wyandotte now, versus Amanda Cheney, 231344 A and B, and then the Southgate matters, 28th District Court case number 240393 and 230806. And counsel?
Attorney Corey Westmoreland, praying on behalf of Ms. Cheney. Ms. Cheney, would you please state your name for the record?
Amanda Cheney.
Okay, so the court was handling the 28th District Court matters. Ms. Cheney was requesting a personal bond or an amended bond of some sort. And in this court's review of Ms. Cheney's criminal history and her failure to appear, the court discovered that we have a warrant for Ms. Cheney for her failure to appear for arraignment pretrial on November 14th of 2023 in this matter. And it's a possession, controlled substance, and resisting arrest. And so counsel will conduct the arraignment only, as we don't have a City of Wyandotte prosecutor today. So I appreciate you speaking with her today. And as to the arraignment.
Yes, Judge, at this time we are prepared to waive a formal reading. My client stands mute.
Reading enter plea of not guilty for purposes of the arraignment. We'll schedule this matter for pretrial in that matter for May 29th. Counsel, do you want to address bond? I mean, I know that it was already started to be addressed
Yes, Judge, I would like you to know that Ms. Cheney is currently residing in Dearborn Heights. She is a stay-at-home mother. She has a 18-month-year-old baby. After speaking with her, she did assure me that she would be appearing at all future court dates. I would just be asking simply for consideration for a personal bond with a GPS tether.
And Ms. Cheney,
Yes.
were you working?
No, I'm a stay-at-home mother. I have an 18-month-old daughter at home.
Okay, and you don't have childcare available, ma'am?
My what?
You don't have childcare available?
My mother is currently taking care of my child right now.
Okay,
But
so
she's older. She's an older lady, and she's just not in a great state to be taking care of my daughter. I should be there. It's my daughter. I should be there.
but also your daughter that you need to financially support as well.
Yes, my mother helps me as well, and her father helps me as well.
Okay, how old's your mother, ma'am?
My mother is 65 years old.
Okay, well,
She's a heart patient.
okay. So it's okay from your perspective for your mom to help you financially, but not help you take care of your daughter so you can go to work and earn money on your own.
No, that's not true.
Okay. Well, here's what the court's going to do. The court previously heard the bond arguments for Mr. Melito. I believe he's on another matter right now. And so the court's proceeding without Mr. Melito, not from any issue on his end. But the court had already heard the bond arguments on his end, and Mr. Westmoreland is present on the 27th District Court matter. And so for the court's going to note that Ms. Cheney has a number of cases that all involve possession of controlled substance matters or possession of drug paraphernalia. And then she has a possession of methamphetamine that she was just bound over for. And Ms. Cheney also has an issue with appearing in court. So for those reasons, the court is not going to amend the bond on the 28th District Court matters. And the court's going to order bond and conditions are continued on those matters. Okay, and then what the court's going to do on the 27th District Court matters is, given the fact that Ms. Cheney is currently in custody on bond, the court's going to order $5,000 personal bond on this matter. And in the event bond is posted or your other matters get resolved before this one, which I don't know how that would occur since it's after this one, the court's going to order GPS tether. So we'll see you back in 2 weeks, ma'am.
Oh, okay.
All right, thank you. Have a good day.
Thank you, Judge.
We are on the record in the matter of the City of Wyandotte versus Amanda Cheney, 231344 ABC. Actually, A and B only, A and B only. And counsel, your appearance, please.
Your Honor, for the record, John Goldthorpe, P. 30758, on behalf of Ms. Cheney. Ms. Cheney, would you please put your name on the record?
Amanda Cheney.
All right, so today's the date scheduled for the arraignment in this matter, and the pre-trial in this matter, and counsel?
Your Honor, I've had an opportunity to discuss this matter with both Ms. Cheney as well as with the prosecuting attorney. It's my understanding, Your Honor, that in return for the plea of guilty to the possession of substance, the resisting arrest would be dismissed. I've explained to her the constitutional rights. She's aware of those constitutional rights, and at this time wishes to avail herself of that.
All right, and so let me just clarify though, counsel, the obstructed vision had already defaulted.
I understand.
So I'm just going to cross that off and I'm going to initial that, okay?
Okay, thank you, Your Honor.
All right, ma'am, please raise your right hand.
Yes, ma'am.
All right, and you heard the plea that your attorney placed on the record, correct?
Yes.
And as to the charge of possession of controlled substance, how do you plead?
Guilty, Your Honor.
All right, and counsel, if you can please ready your client.
Thank you, Ms. Cheney. Back on August 30th of 2023, were you in the city of Wyandotte?
Yes.
And did you come in contact with Wyandotte police officers?
Yes.
And at that time, did you possess methamphetamine?
Methamphetamine.
Yeah, yes. And you knew that was wrong, correct?
Yes.
That's satisfied, right?
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept the plea per the plea agreement, and counsel as to sentencing.
Your Honor, immediate sentence in this particular matter. Ms. Cheney is presently incarcerated in jail. She's waiting a final conference before Judge Thomas Edwards of the Third Circuit Court, and it's my understanding that at that time she will be entering into a plea agreement to a charge of possession of a controlled substance. I believe, again, for those reasons, Your Honor, she's also been incarcerated now for the last, I believe, 35 days.
Not on this. I don't mean to cut you off, counsel, but I just want to clarify. She had a matter in 28th District Court that she was arrested on. She wasn't brought before this court until May 16th.
Okay.
So in this court, she's been in custody for 14 days.
Okay. That's good.
No, that's okay. All right, go ahead, counsel.
And Your Honor, it's my understanding that as part of that plea agreement, which she is going to be entered into, that she is going to be receiving a, I'm just speaking off the top of my head, it's 1 to 5. Oh, it's a plea agreement to, and a sentence agreement for incarceration for at least 1 year. Is that correct?
Yes. I'm going to enter into a plea agreement for 1 year Wayne County, 2 years felony probation, 1 year Wayne County, first year Wayne County Jail.
For a fourth of habitual offender, fourth offense?
That's what Thomas Edwards, or that's what the prosecuting attorney offered me. I go on the 31st to enter into the plea agreement.
As such, we're asking that this court sentence her to 60 days under this charge, and then allow that to run concurrent with her other matters.
What's happening with your matter out of Allen Park from November 9th?
I have wrote out writs and plea by mails to all of them. I'm just waiting on responses.
Or what happened with that one?
I'm sorry, it's a deal or
No, Taylor.
I wrote out writs to both of those, for both of those too. I'm just waiting on responses.
In 2015, there's a possession of controlled substance, pled guilty. 60 days jail, 12 months probation. 2018, felony possession of controlled substance. Less than 50 grams was dismissed, less than 25 grams was pled guilty. 2018, felony controlled substance was dismissed. But there must have been some type of plea because you started your 1.5-year probation. Then you have an unlawful driving away of an automobile, pled guilty, felony, 1 year in jail, and then 3 years probation. Then in 2024, you have the matter of Southgate, the felony dangerous drugs, misdemeanor dangerous drugs, obstructing police, felony weapons offense, misdemeanor. Then you have dangerous drugs out of Dearborn Heights, another obstructing out of Dearborn Heights, this matter that you didn't appear for. Then you have a retail fraud out of Southgate, another dangerous drugs out of Allen Park, and then a retail felony fraud in Taylor, felony dangerous drugs. And you have a habitual offender fourth offense notice on your Southgate matter, and there's a 1 year plea agreement. What this court's going to do is this court finds, based on your criminal history, the fact that you have a pending matter that you're going to be sentenced to as well, this court's going to order 90 days jail credit. What did I say, 15 days?
I think it's at 14, Your Honor.
14. Credit for 14 days. Actually, it is 14 because the 16th was tomorrow, or was Thursday. Credit for 14 days. The court will waive fines and costs. Well, actually, your bond was forfeited, and so the court's going to waive fines and costs. So there's not even anything that I can apply. Good luck to you, ma'am.
Thank you. Good luck.
Thank you.
All right, so we are on the record of the matter of the city of Riverview versus Erica Jackson, 24327.
Your Honor, good afternoon, Richard G. Serrano, appearing on behalf of my client, who's been daytime sentencing. And please state your name, ma'am.
Erica Jackson.
All right, thank you. And Okay, it's my understanding that Ms. Grote, who was a victim in this matter, well, actually, there were two victims. The other one was the driver of the semi-truck. But I don't think that person was notified that the victim was here. But I don't believe it's here any further.
There was no restitution issue, Your Honor.
Oh, I don't think that's accurate, counsel.
That's at least what I got from the report.
I understand that. But it's my understanding that the restitution amount was sent over to Mr. Carmen, and I don't know that that was sent over to the court. So the court ended up getting a copy of it, which appears to be, so I'm not clear on it, is it the $25,120.23 is the restitution amount? Or the cost it's going to cost insurance to fix it, and then Ms. Grote's amount was $1,000 out of pocket. You don't know if Ms. Grote's present, Joe?
I don't believe so, Judge.
So this is your days to date schedule for sentencing on your client's plea to an amended charge of failed to report and no proof of insurance. Counsel, do you have an opportunity to review the report and recommendation in this manner?
Yes, sir, it is. I have reviewed with my client. Probation hold, nothing pending, is that correct, ma'am?
That's correct.
You kind of maybe find cost.
Well, ma'am, you get into an accident and you take off. Why?
Am I honest? I'm not sure. I've never been in trouble before, and I'm very nervous. I'm not sure what am I allowed to speak freely? I don't know what I'm allowed to do and what I'm allowed not to do.
Well, sure. I mean, your attorney's right there. He can direct you if you're going too far, too much afar. But go ahead.
I'm under a lot of this stress with my work and home life. I lost my sister and my dad, and I've been extremely stressed out. And I go to my sister's grave time to calm down for my boss while I'm at work for my lunchtime. And I was just very stressed out that day, and it wasn't my brakes, I just got $900 worth of work done on my car prior to this. It was 3 days prior to this, and when I went to hit my brakes, everything locked up, and it wasn't meaning to, I wasn't taking off, my whole motor, everything locked up, so I don't know, it wasn't intentionally, and I'm truly sorry, and I'm thankful that no one got hurt.
Okay, I'm slightly confused. You hit the person.
Well,
but then you didn't stay there. So you're saying that your engine and everything locked up. That would tell me that it wouldn't move anywhere.
No, when the semi in front of me was having problems, and then the car I was still nervous. So lately with the trauma, my brain's don't process anymore like it should be. So it wasn't intentionally, my car locked up and the accelerator got stuck to the motor. And when it took off, I don't know, I had brakes done, our tie rod, so I don't know. I got it from a tire shop done, so I don't know if they didn't do something right. And when I hit my brakes really fast, everything kind of locked up. And when I was trying to brake it, my car kept going. And when I bumped to the officer's wife, it jammed my accelerator to my motor. And when it cocked back and flew me, and I was trying to stop, and I should have called the police, but I was worried about not stopping. So I wasn't never intentionally to take off. That's the first thing I asked Riverview officers, are they okay? So I worked really hard. I have a 16-year-old son. I'm not on welfare. I'm just trying to make it in this world. It's just extremely stressful. So nothing was intentional, and I am truly sorry.
Okay, I mean, I'm sure that you are. I'm sure that you are. So what I'm going to do is I don't find that that there's reasonable ground. Thank you. That there's reasonable grounds to program scale 769.5. The court's going to order fines and costs only and restitution. So what I'm going to order is I show a receipt of $1,000. Okay, I'm going to order $1,000. If it turns out that the $25,000 here is what's being requested, which I don't think that that's what it is, well, it'll be set for a restitution hearing. All right, otherwise I'm just going to order the $1,000 in restitution to council. If you'd like an opportunity to look at that with your client, it's this last receipt here, at Friendly Lincoln, which shows that, $1,000 was paid. So would you like to look at that, council?
She accepts that, Your Honor, if that's in fact, of course, if it's a greater amount, we would ask for a hearing. But this
No, I
appears to be
understand, yes.
standardized, out of pocket, usually deductible.
All right, and so the court's going to order the following. Court's going to order, it's a $100 fine, $100 screening assessment fee, cost of prosecution $300, crime victim assessment fee of $75, justice system assessment fee of $50, for $625 plus the $1,000 is $1,625. Okay? Do you have any of that to pay today, ma'am? Well, okay, I don't want to take your $40 right now. Okay, so what can you pay per month and what day of the month works best?
I can, middle of the week works best because I pay rent and everything in the beginning of, or middle of the month. Because I pay rent and DT in the beginning of the month. So middle of the month will help me a little bit.
Okay.
$100 a month?
How much? You can do $100 per month? Okay. So I'm going to order $100 per month, middle of the month. Can you start this on, let's say, June 17th?
Yes, that would be perfect.
Okay. Okay. All right, ma'am. Just have a seat over in probation, just in case I need to give you anything regarding, your restitution payment. Ma'am.
Okay, thank you.
Good luck to you, ma'am.
Thank you.
All right, have a good day.
You too.
Thank you. This is the matter of the city of Wyandotte versus Vidal Escamilla, 24415.
Good morning, Your Honor. Neil DeBlois here on behalf of Lydell Escamilla. Mr. Escamilla, state your name for the record, please. Lydell Escamilla.
All right.
Thank you.
Good morning. Today is the date for a bond violation as well as sentencing.
Yes, we're prepared to address both those issues.
Okay, so Mr. Escamilla was, he entered into a plea on May 1st. And the court had amended the bond condition to remove the alcohol tether. And Mr. Escamilla, you were supposed to submit to random testing.
Yep.
You were supposed to then, you're supposed to stop a probation to register, to get the information to register.
So, with that being said, I'm trying to locate the place. I
What
couldn't
place?
locate the probation office.
It's right here in the building, sir.
Well, the address on my paperwork says Lincoln Park.
What? Not
Yes.
for this course, no. You probably were scheduled for on-site testing. That's in Lincoln Park.
That's what the
But
address
somehow you went to probation here first because that's how you got the information. Then you were supposed to register for your testing and you didn't register for your testing.
I had money. I got out of incarceration. Luckily, when I got back to work, I had enough money to pay my rent and my PTE.
Did you at any point contact anybody here at the court regarding that, sir?
No, I didn't.
No. Perhaps the court would have allowed you to just remain on the tether and not do the random testing for financial purposes. But this court gave you the benefit of the doubt, and I removed the alcohol tether and ordered you to participate in random testing, which you did not.
I appreciate you letting me get this tether off.
But
Definitely.
that's how you show your appreciation, sir, by not complying with the court's orders. And what do you think that all of that says to the court? No, tell me, what is it you think it says to the court?
Honestly, Your Honor, I'm doing my hardest. I'm doing the best that I can.
Sir, what do you think that you doing that, pulling that, what do you think that says to the court? Haha, I pulled one over on the court,
No,
got my tether off, not gonna register for my testing, going to do whatever I want to do. I have no regard for the court order.
it's not the case.
So you didn't even contact the court to let the court know that you were having a trouble getting the finances together for the testing.
Right.
You just ignored all of it.
Your Honor, want you to understand, I got out of jail and I had no money. I had enough money to pay my rent and my DTE. I don't even have enough for food right now.
Where do you work, sir? You work, right?
Right down the street.
So counsel, as to the bond violation, what's your client doing? Is he pleading guilty or not guilty?
It's failure to regard.
Please raise your right hand, sir. You solemnly swear from the testimony about to give this matter the truth, the whole truth, and nothing but the truth.
Yes, I do.
All right, as to the allegations that this court has already put forth regarding your bond violation, how do you plead?
Guilty.
You've gone over your rights, and you understand you have the right to have a contested hearing in this matter, correct?
Yes.
And by entering into a plea, you will not have that contested hearing. Do you understand that?
Correct.
Anybody promise you anything, threaten you, or coerce you in any way for you to enter into a plea?
No.
And you understand the possible penalty as a result of your plea today, correct?
Yes.
And counsel, if you can please order your client.
Mr. Mia, we acknowledge that you were ordered by the court to present yourself and register for random drug testing as a result of the underlying case with the guilt. You understand that you had an obligation to register for drug testing. Yes.
Can you speak up, sir, please? Is that yes?
Yes. Do you acknowledge that you failed to do that for the reasons that you stated on the record?
Yes.
I believe that establishes the basis.
We're just finding the plea is knowing, voluntary, and factually accurate. Court will accept your plea to the bond violation. And counsel, as to the sentencing on the bond violation.
All right. Courts would impose any sentence. I'd ask that it would be held in abeyance until he proves himself. Clearly, he should be placed on probation for the underlying offense. Some of the background on Mr. Escamilla, the reason he's here for you today was public intoxication. He was not operating a motor vehicle. He was not a danger to the general public per se. He has no history of, illegal driving or violence or any of those types of things. He's a dishwasher and a seafood restaurant. And he maintains his own living arrangements all by myself. And he, as he stated, he's doing the best he can. I think there's a lot of truth in what he said. He is. Could he do better? Sure. Could have complied with your order. That would have been a start. But I think he's close to capacity for society. He does pretty well. I don't know what his whole backstory is. But that's the worst criminal on the street. Give some leniency here and let him get on with his life. In conjunction with the court will have basically, the court's gonna have to keep an eye on him for perhaps the next 12 months. We follow the recommendation. And as I say, I asked the court to give him some leniency here, give him an opportunity to prove himself.
If you're tested right now, sir, what's in your system?
It's marijuana.
When's the last time you used it?
Probably. It really helps me sleep.
Do you have a valid prescription for it, sir?
No.
Okay. So do you recall on April 17th, this court ordered you not to possess or consume any alcohol or drugs that are not prescribed? Yet you're still using marijuana that's not prescribed. Correct? And you didn't set up your testing like you were ordered to do. You didn't stop using any drugs that are not prescribed as you were ordered to do. Yet your attorney's asking me to give you a chance. You've had 2. And you had a prior one in Southgate in the 28th District Court in 2021 that you had dismissed under 771.1.
I just need time.
And for what, sir?
Honestly, where we move forward through this case put behind me, because I have too many goals trying to reach. I aspire to reach higher,
What are your goals, sir?
to get a vehicle for one, to get out of where I live right now, equals better foundation as far as living situations. So, and with me doing this by myself, it's just me, myself, and I. So, best that I can. I apologize for not forward with this probation. I'm just trying to figure things out.
Sir, I can appreciate that, doing things on your own is tough. I can 100% appreciate that. However, what I can't appreciate is the lack of communication regarding not being able to afford the $37 or the $32, $42 that it costs for you to register for your testing and take your first test.
Your Honor, that's all I literally had on me was $32 after I paid my rent and BTE.
Okay, you pay your rent once a month, right?
Right. But I usually have to take money out each check.
Okay, so sir, do you have a second job to supplement your income?
Oh.
Perhaps you may want to do that part-time. Because you're going to have fines and costs here, and you are going to register for testing today. You're going to test today.
That's fine.
As the bond violation, the court's going to order a $50 fine, increased testing. You're going to register and test today. If you do not, sir, you can guarantee you will be housed in the Wayne County Jail.
I understand. But Your Honor, I got too many people that look up to me. That's the last place I would want to see.
Well, good. Then follow this court's orders.
Look,
communicate with the court.
I promise.
Don't ignore us. As to the public intoxication, the court's going to find that there's reasonable grounds to depart from MCL 769.5 after hearing from counsel, hearing from Mr. Escamilla, reviewing the report, the recommendation. You are eligible for early discharge. The court's going to sentence you to 12 months probation. You're not to violate any criminal law of any unit of government. You're not to say without the consent of the court. You are to report truthfully to your probation officer as long as the probation officer may require, in person, in writing, or virtually. You're notified your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. Rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are to enroll and participate in the chemical awareness program. The rehabilitative goal for that condition is to further educate you about drug and alcohol use so that you may make better informed decisions in the future, sir. You are to perform 5 days on the court workforce. The rehabilitative goal for that condition is to help you further develop work and life skills and get back to the community. And of course, we're going to also order you to obtain your GED or high school diploma. The rehabilitative goal for that condition is to allow you the opportunity to increase your earning potential. You didn't do it on your own, sir. We're going to make sure you do it. You want help in achieving your goals? This is what you're getting. Got it?
Yeah.
As to the fines and costs, the court's going to order a $300 fine, $100 screening assessment fee. Supervision oversight fee is $600. That's $50 a month at 12 months. Since you're eligible for early discharge, you could have that cut in half, sir. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, workforce $200. It's 5 days at $40 a day. Chemical awareness program of $75. So $1,700. Again, $300 could come off, sir, as long as you discharge early. Okay. Now, what I'm going to do, sir, since you're just getting back to work, is I'm going to have you set up a payment plan through probation.
Thank you.
Okay. So I know I went through that pretty quickly, but you're going to get all of this in writing from probation. And then, sir, as I did state, you're eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations. All money has been either paid in full or you made a good faith effort for making full payment.
Thank you.
Sir, don't disobey the court's order again.
No.
All right. Have a good day.
Thank you, Your Honor.
Thank you. All right, let's go off the record for a moment.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
This is a joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Ms. Green, we're gonna start bringing people in person. People are gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, at the end of the day, I'm sitting up here, I'm the one that needs the drink.